what it means, and how to implement this in your county. So please use the chat feature or the Q&A at the bottom of your screen if you'd like to ask any questions. And of course, Andy will be monitoring that and answering questions as he can. And for everyone's information, if you have others that were not able to participate today, we are recording this and we'll make it available on our website as soon as possible. And with that, Andy, I'll turn it over to you.
Thanks, Marcy. I'm smiling because I'm the one who did the abrupt cut on the music. I was trying to share my screen, thinking it was the same title slide as what Anne-Marie had up there. Thank you, Anne-Marie, for putting that together. And I don't think that the recording caught the beginning of your comments. And so for those of you who are watching the recording, putting messages and questions in chat or Q&A is going to result in me taking a look at those questions and trying to answer them. As Marcy indicated, this is our second webinar on Act 4. Act 4, of course, deals with the retirement status of all county jailers within the state of Wisconsin. Our first one was at the end of April. That provided an overview of Act 4, but now we have the date of implementation, the effective date of Act 4 approaching. That's January 1, 2024. And again, good old Andy put 2023 in the constant contact that Michelle sent out. And so we got all sorts of emails. Wait a minute, I thought it was 2024 when this was being implemented. Yes, it's January 1, 2024. So we have less than 3 months until we implement Act 4. So the purpose of today's webinar is to not only provide, again, an overview of Act 4, but also dive into some of the more intricate questions that we've received, and I know ETF has received about Act 4. And so, again, I'm going to really encourage everybody to put your questions and whatever comments you might have into chat or Q&A, and we'll address all of those as we get through this discussion today. Finally, I would like to point out that we've received some requests from counties out there saying, hey, can you do a 10-15 minute video short just on Act 4 and the choice that the jailers have that we can share with our jailers and our new hires when it comes to these forms that we have to use? And the answer is yes, we're going to do that. I anticipate recording that later this week, early next week, making that available through WCA's YouTube channel. So we will get that out to everybody shortly as well. So without further ado, let's talk about Act 4, what it does, and some of the intricacies associated with Act 4. So, number one, important disclaimer, whenever we are dealing with the appropriate category of employees for ETF/WRS purposes, please consult with your corporation counsel. These are very, very important classification decisions because an employee's retirement status hinges upon how they are classified for ETF purposes. So consult with your corporation counsel early and often when dealing with these questions. General versus protective. What's the big deal? Why is it that this is so important that jailers be classified as protective, and what does it mean? At a very, very high level, if an employee is categorized as protective for Wisconsin retirement system purposes, they are entitled to an enhanced benefit offering. This means that the normal retirement age goes down. For general employees, it's age 65 or 57 with 30 years of service. For protective category employees, that's what jailers are as of January 1, 2024. That's what currently sheriff's deputies are and some others. If they are in that protective category, they can retire at age 54 or age 53 if they have 25 years of service. So you can see there's an early retirement benefit there. Second, and this is the other very important concept, is that protective category employees are entitled to what's called duty disability benefits. If they get hurt in the course of their employment, while engaged in their employment that gives rise to the protective status, then they receive certain benefits associated with duty disability. They get income continuation at 75% if they're permanently disabled. And so that's not available to general category employees. So again, it's very important that we have an understanding of the benefits that attach to this whole protective occupation participant status. Why is that important? Because you're going to get questions from employees and jailers about, well, what do I get if I'm listed as protective? What do I get if I'm listed as general? Now, again, this is the overview, and the retirement age and duty disability applies if they're protective. But understand, too, that if there are years and years of creditable service within WRS prior to them making the decision to be protective, then those prior years are not going to count as protective years. In other words, if you have an employee who is, let's say that employee is age 50, they're a county jailer, does it make a lot of sense for them to become protective for the last 5 years of their employment with the county? I don't want to give advice out. I'm not going to suggest that they should or should not, but they should have an honest conversation with ETF and an honest conversation with themselves and their family about what it means to have just 5 years in the system as protective. Again, all the prior years of service are not reclassified. They're not recategorized. It's just from January 1, 2024 going forward. And I see we already have a question in chat. Does Act 4 allow for persons that have opted into the protective category with 30 years of service under general to retire younger than the age of 57 without an age penalty? The answer is yes, but the retirement benefits to which that person would otherwise be entitled if they'd had, for example, 25 years of protected category service, it's not going to be the same retirement benefit. And so while the age category may go down, and that's okay, the retirement benefit is not going to match that. So good question. All right. I'm going to give you a little bit of background and intent on Act 4. And I do this not just to rehash what we talked about at the end of April, but in an effort to understand the foundation for why it is that Act 4 came into existence. And this is important, again, in the communications and discussions that you're going to have with your employees. And so going way back in time, ever since this whole protective service category was invented by the legislature, the statutes contained a laundry list of occupations that automatically qualify for protective service. County jailers were never on that list. Never in the history of the statute were county jailers on that list. And so the question arose, are the jailers engaged in what's called active law enforcement such that they would be entitled to protective category, notwithstanding the fact that they're not on that list? That issue has been litigated over the course of the past 35 years or thereabouts. And historically, ETF has always said, and the courts have always said, that jailers do not meet the definition of active law enforcement, entitling them to protective category under WRS. So why is this an issue now? Why did this come up in the last 10 years or so? Well, because of Act 10. What Act 10 did back in 2011, it divided our employees as counties into basically two categories: general employees and public safety employees. We know that with general employees, the only thing that they can bargain over is total base wage. That's it. They can't bargain over anything else. Under Act 10, public safety employees, however, have the ability to bargain over all things dealing with wages, hours, and conditions of employment, with the exception of certain elements of our health insurance plans. And so it was very important that we have the employees in the correct category for collective bargaining purposes under Act 10. If they're general, they don't get to bargain. If they're public safety, they get to bargain over everything except elements of the health insurance plan. What Act 10 did is tied the definition of public safety employee back to the definition of protective service category under WRS. And so if an employee was under protective service category in WRS, they would be considered a public safety employee. Counties started taking a look at this, again, about 10 years ago, started taking a look at this and saying, well, wait a minute, we don't necessarily like bargaining with our jailers. We don't think they fit the definition of public safety employees. It's creating problems for us. And so we want to look at the categorization that we have for our various employees and make sure that they're categorized appropriately. And so there were 13 counties that said, look, we think that historically we've mistakenly categorized our jailers as protective service under the WRS regulations, thus triggering public safety status under the employment relations statutes. And so we're going to look at how these employees are categorized for WRS purposes, and we don't think our jailers meet the definition of active law enforcement, entitling them to protective service category. Again, 13 counties did this. Over 380 jailers appealed the decision of those counties, and all of those appeals were consolidated. And we had 3 days of hearing to make a determination as to whether jailers belonged in protective service category for WRS purposes. As a result of that litigation, ETF resoundingly again said that jailers do not meet the definition of active law enforcement. Therefore, if you are a county jailer, and ETF looked at all of the various job duties that jailers conduct on a day-to-day basis and so on, and said, look, just as a matter of law, you don't fit the statutory definition, so therefore you're not protective status. All right, so then once that happened, we had a whole lot of people out in the law enforcement community, in county administration and elsewhere saying, boy, this is a really tough blow to our efforts to attract, recruit, and retain qualified jail staff, corrections officers, whatever the case may be, whatever you call them in your county, because we know that state correctional officers get protective status. We know that other occupations may grant additional benefits. And so it's tough for us to try to get our jail staff at full staffing capacity, given that we can't offer protective status, because this is a really difficult job. Counties Association said, we understand those concerns and we want to work with you on legislation that would allow the counties to provide this type of protective status to the jailers. But, and it's a big but, the counties should not be on the hook for the enhanced contribution requirements associated with protective status. And if it's going to be good for one, it's going to be good for all. We don't want a patchwork of different regulations in all of the different counties throughout the state. And so given WCA's position on this, went to the legislature, talked about these concerns, and over the course of the past 8 years have been working on legislation that would allow for jailers to be protective status. But again, it's not on the county's dime. It's not an employer required contribution, and it's going to be uniform throughout the state. Sounds like a very simple concept. It got complicated when ETF's lawyers started getting involved and started dealing with the tax ramifications with the overall system. And so that's why we have all of these opt-out, opt-in requirements that I'm going to talk about here in a moment. It's because ETF could not take an action through legislation that would jeopardize the tax status of the overall Wisconsin retirement system. And so what we have in Act 4 is the culmination of a lot of work and analysis that went into not only the policy behind making county jailers protective, but also ensuring that the tax status of the overall Wisconsin retirement system was not going to be jeopardized. So when people start asking, well, why is it that my contributions are pre-tax and somebody else's are post-tax? Or why is it that I have 60 days to opt in here? I have 60 days to make an election there. You can let them know that all comes about as a result of the desire to give employees the election and the desire to not interfere with the overall tax system of the Wisconsin retirement system. Tax status. We have a question here from Corey. How long would a current employee opting into protective service have to be in before they can retire? That's a great question, Corey, and I don't want to get into the process of evaluating every single circumstance for every single employee as it relates to retirement age. I'm going to refer those questions to ETF because they have all sorts of calculators and personnel that are available to assist employees in answering those types of questions. And that's a very important part here because you'll see that once I get into the forms in a moment. When we get into the forms, those forms state very clearly that we are not giving investment or legal advice. And so employees ought to be encouraged to have a conversation with ETF about their particular circumstance. And I would really encourage folks to utilize the ability to say, please call ETF. Another question. You mentioned this being connected to Act 10. Does the change to protective status also make them protected under Act 10 and therefore full bargaining rights? Kim, great question. I'm going to get into that in a moment, but that was another provision that WCA wanted to make sure we addressed. And that is that we didn't inadvertently create a new class of public safety employees. And so what you'll see is that within Act 4, there is a specific provision that says county jailers are not considered public safety employees. So notwithstanding Act 10's tie-in to protective status to define public safety employees, Act 4 specifically excludes county jailers from the definition of public safety employees. All right, first, and this is an important concept as well. To whom does Act 4 apply? Because we talk about this concept of a county jailer. Act 4 defines who a county jailer is. A county jailer is an employee of a county whose principal duties, 51% or more of the time, all right, that's what principal duties means. Those principal duties involve supervising, controlling, or maintaining a jail or house of correction, or the persons confined in a jail or house of correction. The fact that somebody is sworn as a deputy sheriff, the fact that they may have a title that says they're a county jailer, those things are irrelevant to the definition of county jailer, irrelevant to the determination of who's entitled to protective status under Act 4. All right. So again, I've heard counties say time and again, well, our jailers are sworn. That means they're deputy sheriffs. And since deputy sheriffs are listed in the statute, again, going back to where I started in this conversation with the long list of employees that are automatically entitled to protective status, deputy sheriff is on that list. That's not the determining factor. Sworn status and the fact that they are called a deputy sheriff does not matter. The question here on application of Act 4 and protective status is, are the employee's principal duties 51% or more of the time, do they involve supervising, controlling, or maintaining a jail or house of correction, or the persons confined in the jail or the house of correction? So again, you have to look at what an employee does, not necessarily what they're called. Question. Rose asked a great question about what happens during the interim 60-day period. I'm going to get to that toward the end of this presentation because ETF has addressed that within their FAQs. Joe says, it says the employee is responsible for disability premium. What would this cost? Again, I'm going to get into that as well. So I appreciate the questions, good questions, but I'm going to get into those. Getting into the question of cost. Remember I said that from a WCA standpoint, we wanted to make sure that this wasn't an unfunded mandate placed upon counties for protective status. That if an employee is going to be protective status, if a county jailer is going to be protective status, then the employee, that county jailer, has to pay the enhanced contributions associated with protective status. What does that mean? Well, with our general category employees, it's relatively simple. Every year, we see that ETF comes out with contribution rates, and those contribution rates are split in half: employer share and employee share. Employer share is county responsibility, employee share is employee responsibility. No different for protective status in terms of those two buckets. There is an employer share and an employee share, but with protective status, I like to think of it as a third bucket. The third bucket is the protective status bucket. ETF comes out with rates associated with that protective status bucket as well. If we look at the rates for 2023, we know that Act 4 protective, the employee contribution is going to be 14.3% if an employee under Act 4 is entitled to protective status and that employee does not opt out. The employer contribution will be 6.9%. And so the total contribution is going to be 21.2% for those three buckets. Pre-Act 4 protective, if we have, because we have 13 counties out there that currently bargain with their jailers and currently treat their jailers as protective, Act 4 grandfathers those counties in. I'll get into it in a moment, but again, those grandfathered counties have the opportunity at some point in the future to say, okay, we don't want to bargain with our jailers anymore, so our jailers are going to be under Act 4 from now on. But for those 13 counties that currently pay the enhanced contribution, that third bucket, then the county is picking up that 14.3%. So again, for the vast majority of counties where the jailers are going to be protective as of January 1, 2024, what the employee is looking at for a contribution rate is 14.3%, which is comprised of 6.9% as the employee contribution for just same as other general employees, and then 7.4%. 7.4% associated with that enhanced third bucket for protective status. Now, on top of the regular contributions, we also have duty disability. The duty disability portion is rated by each county, and I don't understand the formula. Don't ask me how it works. That's an ETF question. But typically, it's based upon experience. It's kind of like workers' comp in that you take a look at the prior claims and then your premium is rated based upon the claims history in any particular county. The duty disability premium, my understanding is that the duty disability premium is an additional 0.02% to 0.57% of an employee's total wages. And so when we look at that 0.57%, you add that onto the 21.2%. And in those counties that currently don't treat their jailers as protective, that becomes an employee responsibility. So instead of the employee contribution being 14.3%, if it's 0.57, it's going to be a 14.87% contribution on the part of employees. Okay. Again, we use this as an educational tool in talking with the employees about what is the impact going to be on your paycheck as a result of Act 4. And understand, I'll get into this in a moment as well, that the election, the decision, do I opt in or opt out? What do I do? That's irrevocable once it occurs, so long as that employee, that jailer, is employed by your county. And so this is a very, very important decision that has long-term ramifications for the employees. We want them to be fully informed as it relates to what does this mean for me? And so we want to give them the tools to be informed. As I mentioned before, there are counties out there that currently bargain with their jailers. And like I said before, if you currently bargain with your jailers, you can continue bargaining with your jailers. If part of your bargaining agreement with your jailers says that you as a county pick up that third bucket of contributions and pay that for WRS purposes, you can continue to do that. But as soon as you decide as a county, we don't want to bargain with our jailers anymore, you can just make that decision unilaterally. You don't have to ask the question of the union or the employees. You make that decision unilaterally. You submit what's called a petition for unit clarification with WRS to pull the jailers out of that bargaining unit. And it's automatic at that point that those jailers come under Act 4. And so when those jailers come under Act 4, they have the opportunity to opt out of protective. They have the ability to be recategorized as general. If they do nothing, remember, Act 4 says that all jailers are automatically protective. So if they do nothing, they are going to be considered protective. Okay. Joe has a question. Jane has a question. If an employee resigns and then is rehired as a correctional officer, does the original election stand, or do they get a new opportunity to choose if they want to participate or not? I'm going to get to that question in just a bit, Jane. So just hold tight on that question. Here's where we get into some of the complicated tax implications for the employees. And frankly, from a policy perspective, this makes no sense because in my mind, we're going to treat new hires better than we treat existing employees. Not WCA's decision, frankly, not the legislature's decision. This is all because of the tax status of WRS under the Federal Internal Revenue Code. It had to be set up this way because of the Social Security Act's requirements as it relates to the overall system. So, and again, this is very important. In Act 4, jailers that are hired on or after January 1, 2024, the effective date of Act 4, in a county that did not classify jailers as protective, the contributions made by those new hires are collected pre-tax. For existing jailers, people that are currently jailers within a county that as of January 1, 2024 become protective, if they do not opt out, so they stay in protective status, those contributions are made post-tax. So that's a big deal for employees, the difference between pre-tax contribution and post-tax contribution. Again, encourage employees to get advice from both ETF and their own financial advisor on exactly what this means to them on a paycheck per paycheck basis. In counties where jailers are currently protective, we currently bargain with them, the 13 counties. If down the line, those employees opt out of bargaining, those existing jailers, they make the contribution post-tax, but new hires made after that date where the county opts out, so to speak, they make the contribution pre-tax. So again, existing employees, at least in my mind, are treated a little bit more poorly than the new hires. Again, from a policy perspective, doesn't make a lot of sense, but that's the way Act 4 works. So now we get into the notice and the form requirements. Act 4 has provisions that require a county to provide the employees with certain forms to either opt out of Act 4 for existing employees, or allow employees to make an election as to the applicability of Act 4 for new hires. Act 4 says the jailers, existing jailers, as of January 1, 2024, in those counties that don't bargain with their jailers, so again, the vast majority of counties, those jailers have 60 days from January 1, 2024 to opt out of protective status. We have to provide the form as counties, and I'll get to that in a moment as to what that form could look like, but it's our obligation to provide those forms. So it would be easy if it was a simple question and a simple decision. We provide the form, let the employee read it, sign at the bottom. But I think employees are going to have a lot of questions. And I think we as counties have an obligation to educate the employees as to what this whole opt-out thing really means. All right. So we've developed some forms. And I wonder if, yep, Michelle has just posted in the chat a link to the constant contact that went out to all counties that contain links to the form templates that we have produced. I say they're templates because Act 4 did not require any sort of magic language when it comes to these forms. So we at the Counties Association, I here at Attolles, I and my colleagues here, developed these forms based upon what we know Act 4 contains and what we know the opt-out process and the election process is going to look like. Talk to your corporation counsel, talk to your personnel director, talk to HR, talk to administration about what these forms need to look like for your particular county. There is no magic to the templates, but there is some magic to the specific verbiage contained within the form about the ability to opt out. And you'll note that right here on Form 1, this is for existing employees on Form 1. By signing below, I elect to not become a protective occupation participant. What does this mean? I'm not going to be protective. I'm going to be general category. And I also know that my decision is irrevocable. I cannot come back later and say, you know what, I messed up. I want to change my status. I want to go into protective. You don't get a new election. As long as you are employed by that county, you are going to be considered general if you opt out. My apologies, my screen for some reason went dark. So I'm going to get it back. Thank you for bearing with me here as I attempt to get this back. I'm going to share the screen again. Okay. So now we have a situation where the employee makes that irrevocable election to either opt out, or if the employee does nothing, all right, current employees, current jailers, that as of January 1, 2024 have that election. If they do nothing, they are protective. That means that if they don't sign that form within 60 days, then that means that they are going to be on the hook for those employee contributions, all right? So again, it is a matter of making sure the employees have a solid understanding of exactly what it is that they are electing to do or not to do. Very important concepts. All right, so we've got the Form 1 where we're dealing with current employees, current jailers who as of January 1, 2024 are going to be protective unless they opt out. You'll note that on the template form that we've provided, we've got a place for the employee's name, the employee's signature, the date of the signature, and then at the bottom you'll see there. The form has to be signed and returned. You have to have it by Friday, March 1, 2024. Once the county receives that form, the county goes into the ETF system and classifies that employee, submits the required paperwork to ETF to make sure that the employee is appropriately categorized as general or protective. All right, so that's Form 1. What about new hires and this whole election concept? Well, in counties that do not currently treat jailers as protective, within 60 days of the date of hire, all right, this is again for the jailers that are hired after January 1, 2024. And I'm not talking just about new hires. You could have an existing county employee that decides to take a job within the county as a jailer after January 1, 2024. That person is going to be considered a new hire for Act 4 purposes. We have to provide an election form. Remember that previously with Form 1, this is an opt-out form. And if the employee does not sign this form, then the employee is automatically in protective status. With new hires, it's called an election form under Act 4. In using the template Form 2, that again is contained in the links that Michelle sent out and posted into chat, we have the ability for the employee to either choose to be protective or general. Again, whatever decision that employee makes for that county is irrevocable. And it's irrevocable even if the employee leaves that county and later comes back to the county. So there might be a 5-year break in service between the employee leaving your county and then coming back to your county as a jailer. Whatever that employee elects on this Form 2 or elects on Form 1 is going to prevail as long as that employee is an employee of your county. All right, that's a very important concept, again, that I think we need to let employees know about. What about counties that currently bargain with their jailers and decide after January 21, 2024 down the road that we're going to stop bargaining with them? Remember that as soon as the county makes the unilateral decision to not treat those jailers as public safety employees, in other words, the county is opting out of that, then that triggers the opt-out for the existing employees and triggers the election for new hires. And so we would just modify Forms 1 and 2 to update the dates as to opt-out for current employees and election for future employees. Again, I can't state this clearly enough. The decision is irrevocable as it relates to the relationship between that particular employee and that particular county. Now, if somebody, for example, were to opt out of protective status in your county, and that jailer next year decides to take a job as a jailer in a neighboring county, that jailer gets a new election with the new county. But if that new county, new jailer decides to leave new county and come back to you, whatever the election was when they originally made it prevails even in that future employment relationship. All right. I'm going to take a break for a moment and try to see if I can address some of these questions. Question from Kelly, is the post-tax amount strictly the enhanced amount, or is the general contribution amount still pre-tax? The general contribution amount is still pre-tax. That's my understanding, that Act 4 says the third bucket, the protective bucket, if you will, is the only thing that is post-tax. From Joseph, if you participate in protective, are you able to opt out later if it turns out you no longer want to participate? No. And that's a good question, Joe, that this decision is irrevocable. So as long as you stay with the county, your decision is irrevocable. Question from Sheriff Schmidt, is the entire amount of the retirement contribution post-tax for current employees, or is it post-tax or they pay as general and protective? I think I just answered that, Dale, but again, my understanding is that this does not change the pre-tax, post-tax classification of contributions, the 6.9%, which is the same 6.9% as every other employee in the county pays. Act 4 does nothing to change that entire contribution. We're only dealing with the protective bucket, that third bucket. Since new hires are treated better than existing jailers and based on lateral hiring practices, how do we prevent mass resignations and rehiring? Great question. I don't know how we address that because toward the end of this, I'm going to talk about some of the questions that I've received from various counties about what can we do as counties to try to make sure that it's great that we're implementing Act 4, but this presents some real administrative and policy questions for us. How do we deal with that? I'm going to get to that toward the end. Question from Ruth. Even though existing employees are not required to opt in, is there any harm in having every employee complete something like Form 2 and being clear what they're choosing? I understand if they don't complete, they'll be in, but we're considering having something from all employees so it's clearly documented. It's a great question, Ruth. I would love to use just Form 2 and have every employee complete Form 2 so it's clear the decision that they are making. In other words, it's not just an automatic default to protective status. The way that Act 4 reads, it provides for two different forms. It has the opt-out form for existing employees and the election form for new hires. No idea why the legislature set it up that way. I don't know if it was a conscious decision or not. I tend to think it probably was not. But if we can have all employees utilize Form 2 and do a great job in returning those forms and making an affirmative election, that would be awesome. So there's no problem with using just Form 2 on that as long as we get those forms back. Question from Dave. What would happen if a current jailer is promoted, new job title after 1/1/24? Would their contribution be pre or post-tax? If a current jailer is promoted and they still meet the definition of a jailer under Act 4, then the election that they make is going to continue with them for so long as they maintain their status as a jailer. So the fact that they are promoted from jail deputy to sergeant or jail administrator, it doesn't matter. As long as they're with your county, whatever election they make now is going to continue with them for as long as they're with your county and as long as they meet the definition of a jailer. If, however, we have a current highway worker, for example, that as of February 1 next year decides to take a job as a jailer, they have to elect as to whether they are going to be protective or general. As a highway worker, they're in the general category right now. And so the question becomes, as of February 1st, their date of hire within the jail as a jailer, are they going to be protective as of that date? Chris here says that he, along with another county, checked on the taxation of the general portion, and we were told by ETF that either all is taxed or all is pre-tax. Counties may want to check with their ETF contact. Please do. Chris, thank you for putting this in here. And this gets back to Sheriff Schmidt's earlier question about the tax status of those contributions. My understanding was it was the third bucket that is either pre-tax or post-tax because that's the way Act 4 reads. But I want to make sure that we address this appropriately with ETF and make sure that ETF is on the same page as we are when we're educating the employees. Let's see if the entire employee share, including the 6.9% that all employees pay, if that's pre-tax or post-tax. So let's check on that. All right, let's continue on with the discussion here. ETF has come out with some FAQs, and there's a link on this slide to the FAQs that ETF has come out with in an effort to assist in the education process with employees. Timing and election, because I've had questions from counties. Well, we have 60 days from the effective date of Act 4, that's January 1, 2024, for an employee to opt out. What happens during that interim period, during that 60-day period, if all jailers become protective automatically on January 1, does that mean that if it takes them a month to return the form before they opt out, that they're going to have a month of protective service? No, ETF has made clear that it will be retroactive to January 1 on the opt-out, okay? And so again, ETF is going to work on their system to allow for the retroactive application of the opt-out or the election that employees make. Question for an employee that they may ask. I submitted the required form to be a protective occupation. Well, can I change my mind if it's still within the 60-day decision period? No, if the county has already reclassified the employee with the ETF, the employee cannot change his or her mind. It's irrevocable, all right? Counties are going to have to work on their administrative process for classification of these employees as reported through the ETF system. What I mean by that is that I think as part of the education process with employees, that counties ought to tell employees that on February 28th, for example, we are going to submit all of these changes to ETF. If you don't have your opt-out form back to me by February 28th, you are going to be protective and you are going to be on the hook. And for the current employees, it's post-tax. You're going to be on the hook for those enhanced employee contributions. But if you get the form back to me, for example, on February 3rd, and then on February 15th, you decide to change your mind, we'll let you submit a new form if that's what you want to do. Either way, make sure that you clearly communicate to the employees exactly when you are going to be reporting to ETF and all of the timelines associated with an employee's opt-out or election as it relates to Act 4 status. Question from Jeffrey. If we're one of the counties that have treated jailers as protective since Act 10, do we just continue as we have been? Yes. You get to continue just as you treating those jailers just as you are now. Again, it's only if the county makes the decision to stop bargaining with those jailers or reclassify those jailers from protective to general that Act 4 would kick in, okay? And I just said that it's a decision on the part of the county to say jailers are general as opposed to protective. And you're going to say, wait a minute, Andy, you told me early on that Act 4 makes every jailer in the entire state, every county jailer, protective. That's true. But the trigger, if you will, to bring Act 4 into play, the trigger is going to be telling ETF, we no longer want to have our jailers be protective. What does that do? That means that the county is no longer on the hook for that third bucket of contributions. All right. Next question. Since WRS is on cash basis, will we be reporting employees to WRS for 2024 as having both general and protective contributions for 2024 if they do not opt out? That's getting a bit into the weeds, Jamie, on the reporting on this. I think that if the employee does not opt out, that they are going to be retroactive to January 1, 2024, protective. And so I don't think that it will be both. I believe that the way ETF is administering this is that if the employee fails to opt out within that 60-day time frame, that retro to January 1, they're going to be considered protective. So there would not be two different sets of contributions. Question from Darcy. Will every jailer that chooses to be protective status automatically have duty disability insurance? Who pays that, employer or employee? And will WRS tell us that amount as they do now for our deputies? If an employee chooses protective, they automatically qualify for the duty disability benefit. That qualification is not retroactive. And so if an injury occurred prior to that employee being protective, that injury is not going to qualify that employee for duty disability benefits. But if they get hurt on the job in the course of their employment as a jailer after January 1, 2024, and they did not opt out of protective, then they will qualify for duty disability benefits. The enhanced contribution for that duty disability benefit, which I believe this year is between 0.02% and 0.57%, if I remember correctly, that's an employee required contribution. And again, it's going to be pre-tax or post-tax, depending upon the date of hire for that particular employee. How are deductions handled? Prorated to 1/1 if the employee does not opt out? I don't know exactly how the contributions are going to be handled for ETF purposes, because again, it's going to be whatever the election is, it's going to be retroactive to January 1, 2024. I don't think there should be proration because, again, the election, opt-out, whatever the case may be, is going to be retro to January 1, 2024. So there shouldn't be a proration, but there should be some sort of true-up, if you will, for that interim period. Question over in chat. Do we wait to report the new hire to WRS until after the 60-day mark? Brian, that's a question I would raise with ETF in terms of what the expectation is as it relates to reporting for new hires. And so I don't know what the required timelines are on reporting a new hire to ETF. And so I would ask ETF is if there is any sort of deviation from those particular timelines as a result of Act 4. Let me see here. Christine has a good question. For Form 2, should the language be modified to state within 60 days of WRS eligibility? It could be a part-timer who's not currently WRS eligible that becomes WRS eligible by taking a full-time position in the jail. That's a great point, Christine. So yes, please modify Form 2 to account for that as well. How do you initially enroll a new hire if they haven't decided if they want to be protective or general? Again, let's ask ETF that question, because our reporting initially might be changed retroactive to the date of hire based upon an election that an employee makes. So how does ETF want us to process that entire reporting? Is there a default option if an employee does not turn in an election form? The default is that the employee is going to be protective and on the hook for the enhanced contributions. That's my understanding. Notwithstanding that understanding, Act 4 does talk about an employee making an election. And so it is a required election. If the employee, for whatever reason, doesn't make that election, I believe the default is that the employee will be protective and on the hook for those enhanced contributions. Question from Dave. Great question, Dave. I've been asked this question before. Can we terminate all county jailers on December 31st, 2023, rehire them on January 1st, 2024 for consistency on tax treatment purposes? I can't get into the whole question of what that means from a WRS or ETF standpoint and whether that triggers some of the break-in service requirements or whatever the case may be. That may be an option, and it may be something that counties want to explore. If you do want to explore that option, let's have a conversation with ETF to make sure that they are on board with whatever reporting is going to occur on the part of our county. And let's make sure that we don't have an unintended consequence as a result of that termination. So, Dave, that's a creative solution to get everybody on the same page potentially, but let's make sure before we implement that we've answered all of the open questions that might occur as a result of that type of strategy. Patrick asks, since the additional contributions are post-tax, I assume those contributions will not be taxed when paid out, correct? I don't know exactly what happens with the contributions, shouldn't say contributions, the benefits that get paid out to the employees as a result of their participation as protected with WRS. If their contributions are post-tax, it seems to me that it's kind of like a Roth IRA or Roth 401k in that when the money is taken out, it's not taxed. But I don't know that for sure, Patrick. That's something that we would have to ask ETF. Sheriff Schmidt asked, if a current employee resigns as a post-tax employee and they're rehired at some point in the future, are they still post-tax or do they become pre-tax? Depends on who's hiring them. Remember, the decision is irrevocable as it relates to current county, but if they take a job as a jailer in a different county and they make a new election, then that's going to be a pre-tax contribution based upon that election if they elect protective. If they come back to the original county, their original election prevails, and the pre-tax, post-tax status of that would prevail as well. That's my understanding. If current employees are paying their portion post-tax, does their pension get paid out tax-free or only on the interest? Again, that's a question for ETF. I don't know exactly how that works. Question from Cindy, if this is effective January 1, doesn't the protective have to be withheld effective January 1 no matter what? And then if they opt out, the money is returned. That's a question on implementation for ETF. I don't know exactly how we are supposed to process payroll as of January 1st. Again, I would want to make sure that we do something that is, number one, consistent with ETF expectations, but number 2 does not result in a giant withholding as of March 1st, because I think it would be a very, very tough pill to swallow for us to go to an employee and say, by the way, you're not getting a paycheck in March because we had to withhold the entire paycheck to make the contribution for WRS purposes. So let's have a conversation with WRS and ETF to find out their expectation and then figure out how we reconfigure our payroll so it does not create any sort of big problem for our employees. April is saying here that ETF told her to enroll everyone as protective as of January 1, 2024. And then if someone chooses to opt out, refund them later. And that's certainly an option that you can employ. That makes sense because then you're giving the employee the money back as opposed to having the extra withholding down the line. Scott asked the question, retired age 53, do all 25 years need to be protective? Scott, my understanding is that's the case, is that when we're looking at the retirement age of 53 to get the full benefit associated with protective status, you have to have 25 years of protective service in order to qualify for that benefit. But that doesn't mean that you can't retire at age 53 if you've only got 10 years of credible service as protective. You might be able to retire at 53. The problem is your benefit level is not going to be the same as somebody who retires with 25 years of credible service at protective. Questions about payroll and January 1 being in the middle of the payroll. Will you have to split that payroll? The unfortunate answer is I believe so, because as of December 31st, 2023, a current employee will not be protective. Then January 1, 2024, they are protective. And so they're going to have different contributions to WRS. And so I think we're going to have to split those payrolls. And so then the question becomes, how do we administer this from a county standpoint? And I don't have the answers for this. This is frankly beyond my pay grade in terms of payroll implementation. But if it's easier, we might want to do a 12/31 hard stop on current payroll and then do a short payroll to end the year and a short payroll to begin the year, in an effort to make sure that we get all of the different contributions correctly. Josh says, we've been told that ETF will be creating a version of the opt-out and election forms. Have I heard about this? I've not heard that, Josh. That'd be great if ETF did. I would hope that they're entirely consistent with the template forms that we've created. It was my understanding in Act 4 that since this was a county obligation, that ETF wasn't going to provide the forms, but if they do, I'd love it, because as much as possible, I would like to shift the burden of compliance to ETF, because they're the ones who administer this system and they're the ones who are going to process these forms. And so to the extent possible, I'd love to shift that burden to ETF. I'm not aware of ETF taking on that responsibility, but again, it'd be great if they did. Christy asked the question, if current jailers have 60 days to opt out, January 1 to February 29, do I take the general employee contributions or the new protective out of the jailer's payroll? I assume I take general and then I have to take the difference out later. I think, Christy, that gets back to the question about what do we do on January 1 to implement? And if ETF is saying take out the protective contributions as of January 1 and issue a refund down the line if they decide to opt out, that's what we're going to go with. Again, to the extent possible, let's rely upon ETF guidance on how we implement this so we don't get ourselves into trouble as counties. Mary asked the question, do we need to notify ETF who our jailers are prior to January 1st so they get into protected category January 1, or do we leave them in the general category till we get their election form? I believe, again, Mary, I believe that we have to go into the ETF system and change those employees from general to protective on January 1st. But I would ask that question of ETF. Again, I want to be consistent with ETF expectations on how we are going to roll this out in terms of Act 4 implementation. Ashley asked the question, if an employee chooses to opt out, gets injured during the 60-day window, and then changes the election to opt in before we change their category, will the injury be covered under duty disability? Ashley, again, this gets back to ETF and the whole process here for changing from protective back to general. Remember, January 1, all jailers become protective. Those jailers have the opportunity in that 60-day window to opt out. They opt out by providing a form to the county. The opt-out becomes effective when the county reports to ETF a change in category from protective to general. So if the county never actually reported that category change and waited until, for example, February 28, 29, that's right, we have a leap year. So February 29, in order to make that decision applicable by submitting through ETF, then it would be my impression that an employee, so long as the county has not already submitted that change to ETF, has the ability to change the election, so to speak. Again, it gets tricky and complicated. So whatever we do, let's decide from an administrative standpoint how we're going to process this as a county, and then make sure our employees know these dates. And then we stand by those dates no matter what, because we want to be consistent across the board, and we want to meet ETF expectations as it relates to that consistency. Ryan asked the question, for some years previously protected and then some non-protective currently, how does that impact retirement age? Again, Ryan, that's going to be an ETF specific question depending upon the particular circumstances of each individual employee. So let's ask ETF to address those types of questions. Question from Ronnie, will ETF have a presentation available for all employees before the deadline? I don't know if ETF is going to produce anything. As I mentioned at the beginning of this discussion, WCA was going to have a 10 to 15 minute short video that goes through the basics of this that is going to be made available on WCA's YouTube channel. You can certainly feel free to use that, not use that, whatever you want. And if you think that there are additional materials that you would like to see WCA assist in producing, happy to do that as well. So let us know, let me know, let WCA know what else you would like to see in terms of educational materials that would help with this effort, because I feel it's going to be a heavy lift as we head into November and December, which is always a busy time of the year anyways, as we have to now educate the employees. It's going to be a heavy lift. Following up on April's statement, this is from Ashley. If elections are irrevocable, how can we enroll our jailers as protective as 1/1/24 and begin deductions if an employee later opts out by March 1? Well, again, the election is irrevocable, but on January 1, all jailers become protective and they have a 60-day window to opt out. And if ETF is telling us to treat those employees as protective as of January 1 and begin the deductions from their payroll and then issue a refund, if they choose that they're going to opt out within that 60-day window, that's what we're going to do. So again, it's not that as of January 1 in our reporting to ETF that decision is irrevocable. What's irrevocable is the employee's decision to opt out of Act 4 or a new hire's decision, election, if you will, to either opt in or opt out of protective status. Question from Dave, is ETF providing training education for HR and finance personnel similar to this webinar? I don't know the answer to that question. And I think that's a great question to ask ETF if they're going to produce any sort of information beyond what's contained on the website that I mentioned earlier. Again, visit this website, and this presentation along with the slides are going to be made available on WCA's website following this webinar. Take a look at that site. Take a look and see if any of the questions that you have are answered. And if they are not, let's have a discussion with ETF about what else we need. Rita raises a good point. Will WCA talk with ETF about these issues, or is the expectation that each county reach out to ETF individually? No issue with WCA or me or both of us talking with ETF about these issues. I think that'd be a great conversation. My concern is that we have all of the questions and concerns addressed in one spot, because frankly, we would want to be consistent across the state with what we're telling employees and how we're administering the implementation of Act 4. And so to the extent you want WCA or me or both of us to have a conversation with ETF, we would absolutely be happy to do so. Well, let's figure out what questions we're asking. We can certainly take the questions from this webinar, submit them to ETF. But if there are additional questions, additional concerns, send me an email, send WCA an email so that we can get it addressed with ETF. Tyler had a point here in chat. ETF had a presentation at the Jail Administrators Conference last week, which included a PowerPoint. This might be something that they would share. Agreed. ETF, at least in my dealings with ETF has always been really good at sharing the information they have. We will have a follow-up conversation with ETF about what additional information they're going to share. Number one, we want to make sure that whatever we are sharing as WCA and as Attolles here is consistent with what ETF is saying. But again, if there are specific questions and concerns that we need to address with ETF, let us know about it, and we'll make sure that they are addressed. Question from Darcy. Can we allow our jailers to complete the forms prior to January 1st and collect them prior to January 1, or do we have to wait until January 1? Great question, Darcy. I've been asked that question before. There's nothing that's saying you can't distribute those forms and gather them back. Now, next month, in December, that's all fine and good. But technically, under the law, under Act 4, those employees do not have an opt-out right until January 1. And so I can see some confusion or problems if an employee decides to opt out next week, but then on February 1st comes to you and says, hey, you know what? I know I submitted the opt-out form, but I submitted that form prior to Act 4 even becoming effective. And so I want a new opt-out ability because I don't want to opt out. I want to be covered in Act 4. I want to be protected. I can see those situations arising. So again, nothing prohibiting distribution of these forms, getting those forms signed and sent back to you prior to January 1, but I can see some logistical issues that could arise in the event that we do that. I think a better course would be to begin educating the employees, distributing the forms, but don't have them submit those forms until January 1st, all right? And again, whatever it is that we do, let's communicate it to the employees and say, on this date, we are going to report to ETF your change in status. If you want to change your mind, you have to do it before this date, because once that form is submitted to ETF, it's irrevocable in terms of that election. Let's make sure that we clarify that with employees. Stephanie says, perhaps ask ETF for a phone number specifically for Act 4 questions if ETF is open to having those questions streamlined. I think that's a great suggestion, Stephanie. Mary asks, if there are employees that know they want to opt out, can we collect forms prior to January 1? Again, that gets back to my previous comments about the timing of all of this. Michelle posted those forms again one more time so that it's at the bottom of chat. If you click on that link, you'll be able to take a look at the forms. Let's see if there's other information that we have here. Yeah, this basically goes through next steps, and I've talked about next steps throughout the course of this presentation. When you're developing educational materials, rely upon WCA, ETF, your particular county, in putting together the material that you think is going to help your county the most. Schedule meetings. I think that there ought to be group meetings with employees, and I think there ought to be opportunity for individual meetings with employees. Be careful. I don't want counties to be in the position of giving legal advice, giving retirement advice, financial advice, whatever the case may be. That's not our job. Our job is to educate employees about the choice. And if they have questions about the impact of that choice on their particular situation, give them the information to get to ETF to ask those questions, because we are not qualified, nor should we be in the business of providing that type of individual determination or answering those individual questions. And then create a process that we are going to utilize to implement Act 4, distributing the forms, getting them signed, getting them back to us, having the dates when we are going to report to ETF. And again, whatever we can do, we being me, Attolles, WCA, whatever we can do to assist in this process, we're happy to assist. Just let us know what you might need. So let's leave this open for another minute here to see if there are other questions. Sheriff Torgerson said, informative presentation. Thank you. You're welcome, Sheriff. This can be confusing, especially when it comes to implementation. We attempted to address these questions appropriately in the course of this webinar. Feel free to share the recording of this webinar with anybody you think could benefit from this. And again, we're going to put together a 10 to 15 minute, very abbreviated presentation on this that we're going to post to WCA's YouTube channel that you can use as part of your educational effort. And if there are additional materials that you'd like to see, please let us know. Mark Haybeck said thank you. You're welcome, Mark. Thank you for those kind words. Michelle has posted the link to the area on WCA's website where this webinar will be posted once it's made available. I would anticipate it being later today, but it all kind of depends upon when the Zoom link, the Zoom recording is made available in the cloud. And sometimes it's within a couple of hours, sometimes it's the next day. So check the link that Michelle just posted later this afternoon and by the latest tomorrow, and it'll be available. That is all of the questions that I have in chat and Q&A. Marcy, do you have anything else that we wanted to cover here? Anything that you wanted to say?
No, other than just thank you, Andy, for your time and your diligence on this issue. I know it's a big transition for the counties and for the employees. So I think that it's really wonderful that we've had these webinars so we can help educate everyone out there. So I think with any other questions that anyone might have, they can contact the association directly, or I think they can probably reach out to you too, Andy, if they have more questions.
Absolutely. Feel free to reach out to me whenever you'd like. Email me is probably the best. And so if you email me, then I can answer those questions and gather those as kind of an FAQ on our own to publish back out to all of the other counties. And likewise, Marcy, if you get those questions, let's you and I coordinate so that we get the information out to all the other counties. I don't think this is easy by any stretch. I think in concept, Act 4 seems pretty simple, but when it comes down to the details of implementing, there are going to be all sorts of bumps in the road. And we want to be a resource to assist counties with those bumps in the roads. And you're not alone in your struggle. We've got 71 county jails. Menominee County doesn't have a jail. And so we have 71 different sets of county jailers. And so to the extent possible, we want to make sure that the same information is getting out to all of those jailers. And to the extent possible, we want to make sure that the decisions that counties are making are consistent with the decisions that other counties are making. So all of that said, make sure you send those questions our way and we'll get information out as we can.
Well, thank you very much, Andy. We appreciate your time this morning. And thank you everyone for joining us today. And like they said, keep your eye out on the website and we will post this recording once it's available.
Thank you all very much. Have a great afternoon.
Bye.